All right, welcome. For those of you who don't know me, my name is Josh Blackman. I know most of you actually, which is a pleasant surprise. Don't get that very often with 1L classes. I am so happy you're in this class. This is going to be really fun. I mean that you're going to learn a lot of extensive discussion. I want this class to be as informal and we can make it. With a size of 20, we are at the perfect range for that kind of format. If I had my way, I would rearrange the desks to make a semicircle horseshoe, but I don't have the power to do that, so I won't. I actually tried moving desks; they don't move. So I thought I came here an hour ago. This is my present. So I have pocket constitution. You already have. Give me your friend. I'm serious. Try to bring this to every class. You will be citing it a lot. If you want another one, I'll leave them up here for you to take. So we're going to be spending a lot of time with each other, and I'd like if we can all introduce ourselves. We do this a lot in class, and you're not in this section, so it may not be possible. And your least favorite Supreme Court case. The case you dislike the most from ConLaw. I don't care what it is. So my name is Josh, and the slaughterhouse cases are my least favorite cases of all time. All right, Dad, you want to lead off?
Yes, so the very first one to review, Marbury medicine.
You don't like Marbury?
It's just difficult, really, my first case, but I may change my mind later on.
Okay, all right.
Casey.
Casey, what was your least favorite case?
Anything, the one that's abortion one.
Roe v. Wade?
Yes.
Okay, Roe. Okay, and by the way, you cannot say Plessy versus Ferguson, Korematsu, or Dred Scott. Those are off. Those are too easy. All right, Eddie, what was your least favorite case from ConLaw?
Well, the one that kind of came to mind when you mentioned that first was Marbury v. Madison, only because I found it to be a very confusing.
All right.
My name's Lauren. Was it Beck, the one with the girl?
Yes, this is the sterilization case. That's my second least favorite.
Really great. My name's Kelsey. Right. So I'm gonna go with one that I just thought of. I don't technically my least favorite, but Shelley v. Kramer. Another class.
You don't like Shelley?
They go right now.
Like Rachel? So one interesting footnote about Shelley v. Kramer you may not know, I teach some property as well, is that in that case, 3 justices of the Supreme Court recused. And the reason why they recused was they had racial covenants in their homes. So think about that. So maybe they liked them also. All right. Yes, sir.
Jordan Kinneberg. And I would say my least favorite case would be what's the one after Katz where they ruled that you can. It's one of the
Fourth Amendment case?
Yeah.
Are you talking about phone booth, or what are you talking about?
Yeah, no, not the phone booth one. The one that I guess is after that one.
Okay, so Fourth Amendment case. All right.
Yeah.
Brandon Schilter, and it's been so long since I've had ConLaw.
It'll come back, I promise.
I didn't like when Justice Roberts allowed the new healthcare.
Oh man, now you're speaking my language. So
Because I've been directly affected, and my health insurance is now double what it was, and my deductible is now double what it was.
so you liked your insurance, you couldn't keep it?
Right.
But your 26-year-old has coverage.
Yes. We will be talking about Obamacare. We'll be talking about Obamacare a lot this year, I promise. I promise. Yes.
I'm Ian Nobles, and again, I guess it's been a while since ConLaw, so maybe Marbury versus Madison.
Wow, how people don't like Marbury?
Only because it was controversial.
You didn't learn it right. All right. Yeah.
I'm Zach. I think my least favorite case is probably the Michigan Law School case.
Oh, Grutter v. Bollinger, the affirmative action case. So now let's be precise. The undergraduate affirmative action program was invalidated, but the law school is upheld. Which one do you dislike?
I just like law school.
So you think they should they should have both been invalidated?
I think it should have been treated the same.
Okay, good, all right.
Michael Barkis.
Yeah.
And it wasn't a ConLaw case, but it was a Supreme Court
That's
case.
fine.
Citizens United.
Ah, you don't like Citizens United.
Not really.
No good.
Right.
Okay, very good.
I'm PJ Newton, and I didn't like Marbury versus Madison.
Wow, I might have to do a lesson on Marbury to make you like it. It's an awesome case. I actually,
That's typically how it works. If I hate something, the more I get beat over the head with it, I fall in love with it.
all right, and since you like to speak, what's your favorite case? Or least favorite case?
Well, my name is Jason Wynn.
Yeah.
My least favorite is Wickard v. Filbert.
Wickard. Oh, now you're speaking my language.
I
Okay.
cannot stand that case.
Okay. 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 Now.
My name's Colin Sheldon. I was gonna go with basic, but I'm going with Obamacare for sure.
Wow. Okay. Now you're speaking my language. So for those of you who don't know, I wrote a book on the case. I'm actually writing another book on the case, and I'll bore you to tears with Obamacare later. But we'll do a lot on Obamacare. Start in the back.
My name is Robert DePaulo. Go by Mike.
Mike.
Least favorite can go with Bush v. Gore.
Bush v. Gore. Interesting case. Interesting case. Okay, Matthew.
Matthew Marino and my least favorite case is the Obamacare. I'll just let me down. So.
Man. All right. Here you go.
The New Jersey versus TLO case, the student circumcision.
Really? That one really bothers you? Interesting. Okay. You went already. Okay.
My name is Chris. My least favorite is Roe v. Wade.
Roe v. Wade. Okay, have another row. Okay, in the corner.
Gwen Elliott, and I don't remember the case name, but it was about, in ConLaw I had also, and it was about the right to die.
Ah, Washington v. Glucksberg. This was the assisted suicide case. Right? Is that the case you're thinking of?
Mm-hmm.
And you don't like the decision?
Mm-hmm.
You think people should be allowed to have a constitutional right to assisted suicide?
Choice.
Okay. All right. Very good. So that was a nice icebreaker. It also gave me a nice valence of where you're all at. I consider asking what's your favorite case, but that one's too easy. So least favorite case requires you to show some criticism, which is a very good lead into this class. So my goal for this class is twofold. Okay. First, I want to teach you about our Constitution with a focus on federalism and the separation of powers. Okay. Almost every single one of you who mentioned a case mentioned something about the Bill of Rights, the First Amendment, the Fourth Amendment, the Fifth Amendment, the 14th Amendment. A couple of you mentioned things involving the Commerce Clause. Almost none of you mentioned something involving the 10th Amendment. Our goal for this class is to forget about the Bill of Rights. They're ancillary. What we're focusing on here are the structural protections of our Constitution, both the good and bad. Okay, so that's the overall arching focus of the class. Second, I want you to write a damn good paper. And I mean that. Far too many people graduate law school with actually writing a really good paper. I'm not talking about your memo for legal writing or your appellate brief. Those are very important skills. But the thought process that goes into writing a paper for a seminar like this, I'll discuss the requirements in a moment, trains your mind in a way that legal writing doesn't. Your goal here isn't advocacy. And that's going to be something very difficult for South Texas students to grasp. Your goal here is thought and thinking about issues in a cerebral way and trying to come up with ideas. A couple of you mentioned the Obamacare case. Believe it or not, if I had gone into law school, any law school in the country in 2009, and I explained to students that a law requiring you to buy health insurance was unconstitutional, they'll have laughed at you. What turned the tide was a number of law professors whom I'm very fond of, who wrote articles and actually changed the face of constitutional law. The Obamacare case you're studying didn't exist 3 years before. The idea that there was a distinction between activity and inactivity, that didn't exist. So no matter how good you are as a lawyer, you need people who can think of ideas to bring into court. That's my goal for this class. Okay. I assume most of you got in the textbook. Just so you know, the American Constitution is not this. It's an actual, Eddie, hold up your book, please. It's an actual book. I'm sorry I have to make you buy another book. I considered just giving you edited cases, but they're way too long. So this book is good because they cut the cases down well. I'd rather give you cases that are edited than just hand you a PDF from the Supreme Court, way too long. The other book, pull that one, please. Okay. It's a short one, but it's very good. And if you don't want to buy it on paper, it's on Kindle. You can buy it anywhere. It's a book called Academic Legal Writing by Eugene Volokh. I think it's in its 4th edition now. This book we will review every week and it guides you through the process of putting together a very smart paper. Okay, so this class will be mostly about common law. We'll do a lot of the case you studied in the past, but this is not going to be lecturing. I'm not going to talk that much. I want to discuss with you some of the themes which you did not have enough time to focus on in common law. In common law, it's a blitz, right? You're trying to force doctrine down in a 2-hour class. It's not nearly enough. We're going to take a much more leisurely pace, but that means I'm not going to go over the facts of the case, right? I'm not going to make someone recite for 20 minutes what the holding and the facts are. I'm going to expect you to come to class knowing those things. But the discussion will be a lot more engaging, all right? So you have the book, you have the legal writing text. Here's the syllabus. It's online. I sent you all the link to it, but if you ever get lost, just go to joshblackman.com. There's a link for classes. I'm going to stand up. There's a link for classes. You click the classes link, you'll find the, oh, I have a thing. Doesn't work. Never mind. Ooh, wait. There we go. So you'll find everything you need to know. I realize this is fairly a small font, so you probably can't read it, so I'll make it a little bit bigger. Your goal at the end of the semester is to turn in a paper, and according to the school handbook, it has to be at least 5,000 words. That's not a lot. I suspect that almost everyone in this room will go over that, which is fine by me. But that's the minimum. But I expect much higher of the people in this room because I know a lot of you, so I expect good things. The general topic of your paper has to do with something about federalism and the separation of powers. I'm going to construe this very broadly. Anything affecting that topic, I'll probably be okay with. But I have to be a little bit paternalistic here, which I usually don't like to be. But this is to keep you on track, all right? So there are several stages of this class that you have to be aware of. And what are my stages? You can't just turn a paper into the last day of class. That's not how this is going to work. And trust me, this is for your own good. So your first deadline comes up pretty soon. And you're like, oh my God, a deadline in 3 weeks. Trust me, you want to get your topic done as soon as possible. I've advised a number of students on law review and otherwise to wait till the last minute, and it's a mess. It's a mess. So by Sunday, February 8th, okay, I want you to send me a 1-paragraph proposal for your topic. And this is something which you discuss with me. Now, if you want to discuss with in person or email, I prefer person, but if you want to send me an email, that's fine. But basically, you need to discuss with me first and then put together a 1-paragraph topic summarizing your paper. You're going to thank me for having this done, all right? Roughly 1 month later, on March 8th, which is roughly 2 months from now, okay, I would like an outline of your paper, and I'll discuss what the outline entails, right? It's not, it's basically the Roman numeral headers, right? It's nothing substantive, but at least shows me that you've thought through the entire flow of the article, okay? The last 4 classes, I'm going to expect you all to give 10-minute presentations on your paper. We can discuss the format of this later, but that will probably consist of you speaking for maybe 4 or 5 minutes, and then your colleagues asking you questions, and I'll probably throw some questions in also. You have to be present on these days and show respect for your classmates. Be aware of what they wrote, and they'll be aware of what you wrote. It's a very good reciprocal rule. The golden rule works quite well. So yeah, so basically 10-minute presentation, and then maybe 5 or 10 minutes of questions, so you'll have plenty of time, okay? Now the deadline for the paper, and this is where my libertarian paternalism kicks in, varies, okay? In my mind, one of the most important aspects of the paper is what's called the introduction, right? This is the first section of an article that basically gives you a roadmap, if you will, of your article. If you give me a 500-word roadmap, your deadline gets pushed till May 14th. You get an additional 11 days to write it. That's the last day of the final period. I can't push it any later than that. That's it. If you decline to do this, which you're free to do, your thing's due May 3rd, which is the beginning of the finals period. So in case, this is what we call a nudge, right? Not a shove, but a nudge. I'm using choice architecture to frame the issues so that you do the right thing. So in other words, give me the outline, you get another basically week and a half to do at the end of the semester, which if you look at your finals exam schedule, you will appreciate this very much. Okay. These are for your benefit. For some of you, this might be your first seminar you've taken, and you may have never done something like this before. This is not like a lecture class where you kind of just show up to class and do whatever. This is an engaging class, which I think you will get a lot out of. I'm not going to do much lecturing. I want you to be prepared. I will guide you. I want to be a facilitator of discussion. I want you to keep it civil. I want you to keep it respectful, but you can get passionate. And I think in a number of cases we'll study this year, you will get passionate. As far as office hours, I teach from 9 till 11 from 9 to 11 on Thursdays, and I have nothing till 5. So basically the entire day on Thursday I'm free. I mean, I wrote from 11 till 12, but odds are if you email me anytime on Thursday before class, I'm free. If you want to meet me after class, if you have a job, whatever, I'll stick around. The amount of attention I can give you in this class is infinitely higher than that I can give you in a first-year class. I'm sure you'll talk to your professors. In an 80-person lecture, you can't give individualized attention. Here I can, and that's something which I'm looking forward to. I'm very good with email. For those who haven't had me, I should respond in a few minutes to any emails. I record all the classes. I have my laptop running right here. They go on YouTube right away. Try not to miss the classes. It's once a week. It's not that much of a burden. Okay. I'm going to run you through. Oh, and here's an added benefit. So I teach ConLaw in the morning, and I structured my class that whatever I cover in the morning, I repeat at night in depth. And that was somewhat deliberate. If any of you are interested in auditing my ConLaw class in the morning at 9, you're welcome to. It's going to be the exact same material. So like this morning, I covered the Declaration, the Constitution, the Articles. You know, next week, we're doing Youngstown and McCullough. That's what I'm covering in the morning. So if any of you want to come and sit in my ConLaw class, means in room 416 from 9 to 11, you're welcome to do it. I might call on you, but I think you'll enjoy it. Especially if you thought ConLaw was a little bit too fast last year, this gives you another bite at the apple. There's no obligation. No way should you feel compelled to do so, but I think it'll make this experience a lot more fulfilling. Okay, so we start off with the today, the Constitution, some of the Federalist. Next week, we move on to the separation of powers, one of my favorites, Youngstown and McCullough. Then we move on to a case that was decided after I taught many of you, which was null canning. This was the recess appointments case. And we're going to talk about this. The week after that, we're talking about Congress and the president. And this is a very timely topic with non-enforcement of the law. Can the president decide not to enforce the law? And this is something which I have a little too much experience on at the moment. I'll explain that later. And folks, at this point, this is when you need your one paragraph proposal. So it comes up pretty quick. So start thinking about it, email me, talk about it. Then we move on to Congress versus the states, which is another aspect of federalism. We talked about the 9th and 10th Amendments, Gibbons v. Ogden, and Darby. Okay, and then there's no class on 19th. Then we move on to everyone's favorite case, Obamacare. Yeah. So we do South Dakota v. Dole, Prince, and NFB v. Sebelius. That class might go a little bit long, but I have some stuff to say about that as well. Then we move on to another aspect of federalism, which is sovereign immunity. You probably gloss over this in ConLaw, but these are important limitations on the ability to sue the state. These are actually very big. If any of you ever do any personal injury work or want to sue the state, these are the actual cases you need to rely on. So these are very, very important. Okay, and at that point, our last substantive class is March 5th. After March 5th, I don't give you any more cases to read. And that's done deliberately, so you have enough time to think about your paper. So on March 12th, we have a full-time class to discuss your writing of your paper. Then we have spring break. Your introduction is due that weekend. And then by the 26th, we start presentations for 1 week, 2 weeks, 3 weeks, and 4 weeks. So that's a semester. So effectively, you only have, after today, 7 substantive classes, right? So take it seriously, but enjoy it. And then after that, we'll develop and build more. Okay? All right, I'm going to shut now. Questions? Anyone have any thoughts? Okay. So to start off this discussion, and unlike my other class, I won't go up and down the rows. I'm not going to do that here. I want people to raise their hands. The theme that I wanted to do for the first class is to trace a pattern of federalism through our founding documents. And I want to look at this through the lens of Federalist number 51. One of my favorite quotes. Madison wrote that ambition must be made to counteract ambition. Several of you wrote that in your exams. That you cannot suppress in men and women the desire to accumulate more power. And the only way that any government could ever achieve the goal of suppressing that ambition is by checking it with other ambition. Power must check power. So let's walk through, and I'll call on someone in a moment, the Declaration, the Articles, and our Constitution of how the problem emerged from the failure to check power. Nice. So who has any thoughts on this? What aspects of the Declaration represent a failure of the checks of power? Yeah.
What was it like with when they were talking about how the king is a tyrant?
Good. What allowed the king to be a tyrant?
Because he was a monarchy.
Mm-hmm.
And there weren't like any checks of power.
How did the king exercise his power?
Well, didn't he assigned governors, I guess, or they would go to the colonies,
Mm-hmm.
and then and he also sent troops as well to the colonies. So
Because the colonists had no representation in Parliament,
Exactly.
so the king was all powerful
Right.
in the colony.
Right. So there's a couple levels here, which you both just said. And the one, he was a monarch who had absolute power. So first, he had absolute power over the colonies, right? As Jason said, there was no representation. The members of the colonies could not go to Parliament. But even more so, could Parliament check the king? Why not?
Because if he didn't like him, he'd kick him out of Parliament.
Yes. So we have here from the pen, or actually quill, of Thomas Jefferson, about 30 grievances that the colonists waged against the king. And the very first one recognizes the failure of checks and balances. He has refused his assent to laws, right? What does that mean? The king in England needs to sign off on all the laws. Parliament can pass a law, but unless the king gives his assent or permission, the law is dead.
I think we have executive orders.
We'll get to that in a minute. So the problem arises where Parliament is passing laws, the colonies are passing laws, but unless the executive is forced to execute them, there's a serious breakdown of the separation of powers. And read number 2. He's forbidden his governors to pass laws, and he suspended laws. Now, when I say suspended, think back to Bart Simpson, right? When you're suspended in school, you're stuck. You can't go anywhere. The idea of the suspension of laws was a serious problem, where the king would simply say, you know what? I don't like these laws, but ignore them, right? He's called together bodies far away. He has dissolved representative houses. What does that mean? When Parliament didn't like what the king was doing, when the king didn't like what Parliament was doing, he said, okay, guys, go home. Go home. You can't pass any more laws. So one thing which you don't appreciate is these weren't just grievances from the point of view of the colonists. These were grievances of the English people themselves. The king was bad to the colonies, but he wasn't that much better to his own people, right? So what lessons, right? What lessons do you think the colonists took from this session? I mean, how do you think this influenced their thinking?
It's important to check executive power
Exactly. How do you check executive power?
through multiple branches of government.
Exactly. Okay. This was an idea that was only in theory. So if you study political science, there was a guy named Baron Montesquieu, who's a French scholar, who had this idea of separating powers. You have the executive, you have the legislative, and you have the judicial, right? These aren't structured in that manner by accident. These are framed in a very deliberate way to check the powers of each other. If you keep scrolling through this list of grievances, you find that not only did he not execute the laws, not only did he fail to allow the parliament to work, but he's refused to establish a judiciary. The only judges that exist are dependent on his will. So we talk about, in our Constitution, we have judges with life tenure and guaranteed salary. That's why. Because when the judge depends on the king for his salary, and if the judge doesn't write the correct opinion, his salary goes away. His position goes away. So it's this perfect storm, if you will, of when you have a monarch, that all these checks are gone. And when you eliminate all of these checks, then the bad stuff happens. You have all these officers who can harass people. You can create standing armies because the legislature can't say no. Under our Constitution, only Congress declares war, not the executive, right? You can put up these mock trials without a jury. What's to stop him? Okay. By the way, there was an English Bill of Rights. Everyone know about this. The English Bill of Rights, you can Google it, had all these beautiful protections for liberty. The right to jury trial, the right to this, the right to that. But what's to enforce it to work? I'm asking, so how do you make a Bill of Rights function? What makes a Bill of Rights actually matter? Anyone?
They have backing.
What's the backing?
Like that they have, you can just have a piece of paper. It's not the piece of paper. It's the fact that you have something that's enforcing them and it's making sure, like we have the systems that check and make sure each system is abiding by what's set up.
Yeah, and that's an important point. Yes, Jason.
I was gonna say it's the balance part of the check and balance. You're giving authority to multiple parties, and those multiple parties will take the authority given them. So, and therefore they create their own power and then obviously check each other.
Exactly. The mere fact that you have a Bill of Rights doesn't mean a thing. England had a Bill of Rights. It was a beautiful document. You can Google it, right? Yeah, the right to jury trial, the right to this, the right to that. But if the executive doesn't want it, it's have to comply. If the executive is paying all the judges, your rights aren't protected. The mere fact of having a Bill of Rights doesn't get you very far. Justice Scalia is fond of saying that every two-bit dictator in the world has a Bill of Rights. Go read the Venezuelan Bill of Rights, right? Go read the Soviet Union Bill of Rights. It's translated. You can find online, right? I even have a copy of the Palestinian Bill of Rights. Go read these documents, right? You'll find all these protections of various rights: the right to this, the right to welfare, the right to food, the right to clothing, the right to housing. But unless you can actually have someone enforce it, these are parchment barriers. And you've heard this expression. What's a parchment barrier? What does that mean? Parchment barrier. Anyone ever hear that? Yeah. You just knock right through it. Okay? So Jefferson concludes, he's abdicated government. He's basically placed the colonies under a total despotic rule. All right? The colonists petition for redress from all these injuries and say that this is a tyrant, not worthy of a free people. And what's interesting about the Declaration is that he's not only speaking to the king, but to the British brothers, saying, listen, guys, we know you have it pretty bad too. We don't want to do this, right? But we want you to know that in peacetime, we're your BFFs, right? But in time of war, because you're suppressing his rights, we're your enemies. The Declaration, in every sense, was a legal document. It was declaring to the world, like, listen, this is why we're separating, because of all these injuries which result from failure to check the power of the executive. Because when the executive's power is not checked, it's not too far from tyranny. And it's for that reason that these bonds have to be totally dissolved. And I love this paragraph. This paragraph is one of my favorites. This paragraph charts the evolution of colonies to states. Read this sentence. That these united colonies, so you start off as colonies, are of right free and independent states. That with that one sentence, they've just dissolved the bonds with England. It's remarkable linguistics. My hats off to the authors with Jefferson and Adams and Franklin, among others. And even this expression, which some of you may not have thought about. Today we say the United States of America is a wonderful country. Is, singular. That's not how the phrase was used back then. It was the United States of America are, plural. There were 13 United States of America. So from the outset, there was this sense that the states were independent but together, okay? The use of this phrase, United States of America, had never been done before. I think Jefferson didn't quite make it up, but it really had not been used this way. So now we have these free and independent states. We're able to work together in common union, okay? And what's important is as independent states, what can they do? Make war, treaties, commerce. That now as free states, they're able to create this, okay? So, you know, you always see this picture on the 4th of July when you're eating your hamburgers, right? Of the Declaration of Independence. And you always see John Hancock's signature. It's faded, but it's really big. Why was it so significant that they put their names on this document?
They told the British government who they were.
More so.
They put like a target on their back.
So they could hang together.
It was a death warrant.
Separate.
They were signing a death warrant. By signing this document, they committed treason. This is not a close call. If the English had won the war, they would have been hung. This was their death warrant. Imagine signing your own life away with this. So it was a cause which they had believed in sincerely, and these 56 names have significant weight. Okay? So questions in the Declaration. Any thoughts on that? At the very outset, from the birth of our country, we see this sense that the inability to check the monarch leads to tyranny. And this was something which they recognize very, very clearly. Okay? But the Articles present something of a different problem. What happens when there are too few checks? Right? When you have one body that's very powerful and the other body that can't really fight back. So I'm sure many of you know this from your studies, but what were the primary deficiencies of the Articles? Yeah.
The state legislature, for one, was too strong, and also the central government had no ability to lay tax.
Very good. So we have this weird situation. Anyone else? So we have this weird situation, right? We went from one extreme to the other. With the king, the executive had all the power, and the states were effectively meaningless. But with the Articles, it was the exact opposite. The states had all this authority, and the executive was minuscule. Does anyone know the name of the first president of the United States of America? Someone say Washington. It's not Washington. That's what everyone thinks. It was a trick question.
Like, I'm not gonna say it.
Guy named John Hanson, not related to the Umbop Hanson, right? John Hanson. You've never heard of him for a reason. The reason is that under the Articles of Confederation, president didn't even matter. The president wasn't elected by the people. He was appointed by some of the other representatives in the Congress. He had no responsibilities, no job, couldn't do a damn thing. He was basically a speaker of the House.
So in a sense, he's like the secretary of the United Nations now.
Even worse. Even less authority than the Secretary of the United Nations. At least the Secretary of the United Nations is a nice building in New York. This guy had nothing. Like the Secretary of the UN could double park. You know, I mean, this is even worse. So those who don't know, in New York City, diplomats are very bad at double parking because they don't have to pay their tickets. So if you ever go to New York City when the UN's in session, the entire road's lined with these double park SUVs, which is if you grew up in New York, it's a thing. All right. So the articles try to take this in a very different direction, right? They're trying to say, listen, we had this really dangerous executive, this absolute monarch. Let's try to take all the power away from this central authority and let's give it to the states. How'd this work out? Someone else, raise your hands. PJ, how'd this work out? How did it work out in the articles when all the states gave up their authority, when there was no authority for the national government and the states had all their local authority? How'd that work out? Bad. Why was it bad? What do you think? No, you don't actually need to know the answer. What do you think is going to happen when you have a system where the national government is very weak? How do you think the state's going to react to that?
They just do what they want.
They do what they want. And how do you think that works for a nation?
Not good.
Not good. Matthew, you're shaking your head. Why is it not good?
I was just gonna say, so whichever the bigger state was that had the most power, it basically just kind of reigned over the other states.
Good. Good. So we had states of different sizes, right? You had a small state like, New Jersey, and you had a humongous state like Virginia with a lot of different people in them, okay? So what's interesting is that in the Articles of Confederation, which is called here a perpetual union, right? In this Article of Confederations, this firm league of friendship, all of the states in Congress had one vote. Virginia had one vote. New Jersey had one vote. What do you think that does when a huge state that's so populous has only one vote compared to a tiny state like, New Jersey or Vermont? What do you think happens there, Kelsey?
They're obviously going to argue because they think they should have more power because they have more people behind them.
Exactly. And who's going to resolve those arguments?
There's no central government.
You see the problem, right? That your hand up?
Yes. It's bad because one of the examples in the book, when we read the history books, is when General George Washington tried to pay his soldier.
Good. Tell us about that. What happened? What was the problem when Washington, under the Continental Army, was trying to pay his troops? What happened?
He has no money. The state doesn't want to pay up.
Good. So today, it's January. What's coming up is tax season. You pay your taxes to the IRS. The national government has a means of collecting taxes. Under the Articles, who collected the taxes? The states. The states collected taxes. What incentive do you think the states had to collect money for the central government? None. Even more so, what would happen if the states didn't collect money for the central government? Nothing. Okay?
And the central government couldn't even take on debt because it had no ability to collect money. And obviously, it had no backing, so nobody was going to lend them money.
Exactly. So we see here what happens when you have an extreme, right? They tried to make the central government so weak, they couldn't demand money, they couldn't collect taxes, right? They couldn't actually pass any meaningful laws. In the event of a war, as Dat mentioned, they were basically relying on the states to maybe contribute money to fund the soldiers, right? This was a huge problem. In fact, this document was actually drafted. If you go all the way down to the bottom, I think it's in 1778 or so, 1777, yeah. So basically, barely a year after independence, they drafted this document as the war was fighting. It wasn't ratified until 1781, which was when Cornwallis surrendered, right? So we actually have this situation here where they designed a government that didn't do very well. The provisions of this government rendered it meaningless. So I want to focus on one provision, okay? Can the Articles of Confederation be changed? Yes. Okay. So it says here in this paragraph, it's not ideal, I can't quite see it, but it says here, right? The union shall be perpetual. Any alteration must be agreed to by every state. Why do you think this provision was put in here, that every state had to agree to changing the articles? Kelsey?
Because it's been nearly impossible to get all of them to agree with it, so it makes it more difficult.
Exactly. Think about this. There's a reason why in our Constitution, which we'll get to in a minute, you can pass the law with the majority. To remove someone, you need 2/3 in impeachment. But to amend the Constitution, you need 3/4 of the state. Each level adds complexity, and it makes change harder. Was this meant to be a document to be easy to change? No. Why do you think the framers didn't want it to be easy to change? George, what do you think?
Because if they made it easy to change, they could just, shift the power around and back to square one.
Exactly. They had just lived under a king who changed the laws on a whim. Oh, today you'll have a stamp tax. Tomorrow you'll have a tea tax, right? Now we're going to dissolve all of your courts. They were effectively trying to institute a phrase we're going to be using a lot this semester, gridlock, right? They were trying to jam up the government and impose structural barriers to passing laws. If you need all the states, you need Massachusetts to agree with South Carolina on a change, that's going to be really tough to happen because the states have such different interests. Massachusetts was very industrial with trading and commerce, and South Carolina was very much into agriculture and slavery, which we will discuss at various points. So they had very different interests, right? So the articles were, call it a draft, if you will, right? It was an attempt to get a government. And in fairness, they wrote this in the middle of a war, right? This wasn't a very well thought out document. All the greatest minds were off on the battlefield. No, they didn't have time to sit and think about it. So we can cut them a little slack. But the problem with the articles became very clear soon enough. And a convention was appointed in the summer of 1787, whose purpose was to amend the Articles of Confederation. But they didn't amend it, they ended, right? They had a deciding vote to get rid of it. Which brings us to our Constitution, right? Which brings us to the Constitution. This is a document which you all have in your hand, because I know I gave you one. And this is a document which we'll be referring to over and over again throughout the semester. The reason why we were referring to it so much is perhaps more in the history of the world, it made the separation of powers the mechanism to protect freedom, happiness, and human flourishing. Okay, so let's see. Lacey. Here. Okay, I'm sorry, Casey. So was there any obligation to pass amendments to the Bill of Rights? Was there anything that required Congress to pass the Bill of Rights?
No, except it would be hard to do a lot of things in the Constitution without them.
Like what?
Actually protect people's rights.
That's the exact thing I want to disabuse you of. So what's interesting, and this is what we all led to think, that without the Bill of Rights, we'd be screwed. That without the Bill of Rights, we'd have no freedom. So I'm about to blow your mind, right? So we look at the First Amendment. Congress shall make no law abridging the freedom of speech. Let me ask you a question. Where does Congress have the power to pass law abridging the freedom of speech? What gives Congress the power to pass any law limiting your speech?
We do.
What happened?
We elect them to represent us.
Where in the Constitution, which enumerated power? Anyone? Give me a guess.
Necessary in order.
Necessary and proper to which power, though?
Just say any law that we deem necessary.
The answer people usually say is commerce, right? Because virtually every single law which is passed is under the Commerce Clause. But there's nothing in the Constitution that gives you the right, that gives Congress the power to limit speech. No such provision exists. So in the minds of many of the people in the founding generation, it was unnecessary to have a Bill of Rights. This national government wouldn't have the power to make any laws. So I often use this thought experiment, right? The Constitution was ratified in 1789. I'm sorry, it was ratified in 1789. The Bill of Rights was ratified in 1791. There was a 2-year gap there between the Bill of Rights and the Constitution. During that time, could Congress have passed a law banning political speech? What do you think? What do you think, Eddie? In that two-year gap.
During that period, could they have passed a law banning?
Political speech.
I'm thinking that maybe you're probably going to say no.
I'm not going to say anything. I'm saying nothing.
I'm wondering if by implication, in the interest of social stability, social contract, and peace, maintaining peace, that they could have found some constitutional basis to do that.
Interesting. Jason, is your hand up?
I mean, Congress could have done whatever they wanted.
Really?
And they did with the Alien and
You saw my next question. Okay.
Afterward, even after.
You jumped my gun.
But that doesn't mean it would have been, there was a check on it.
Okay. So here's the point. There were actually a lot of people in the Constitutional Convention who feared a Bill of Rights. Why would anyone fear a Bill of Rights? Right? Why would anyone possibly not like the Bill of Rights? So do you remember contracts was a doctrine called expressio unius? Shannon?
If you just list out those 10, there's going to be a whole bunch that aren't included.
Exactly. So if you remember in contracts, it says there's this canon. The exclusion of one, or the inclusion of one means exclusion of the other. So basically, if I give you a contract saying, I will pay for your breakfast, lunch, and dinner, and then you say, what about snack time? No, you say expressio unius, right? I listed 3 meals, breakfast, lunch, and dinner. I didn't mention snack time, right? The same exact principle of contracts applies to constitutional law in a way that you may not have thought about, in the form of the 9th Amendment and the 10th Amendment. Okay? It says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. This fear was that if we list these 10 rights, that's all we have. We won't have any others. So what it says here is just because we list a right doesn't mean there aren't others retained by the people. There's this great discussion during the Constitutional Convention with this guy named Sedgwick, who's from Massachusetts. He said, do I have the right to wear a hat? And you have the right to wear a hat. Of course you have the right to wear a hat. He says, well, where is in the Constitution? Where does it say I have the right to wear a hat? Nowhere to be found. Why? Because we have a lot of freedoms which aren't written down anywhere. And this is what the 9th Amendment, which is heavily debated, but at a basic level recognizes. Okay? We'll come back to the 10th Amendment in a few minutes. But before I go to the actual Constitution, I want to focus on the Bill of Rights itself. All right? Let's see. Oh, your name's not Robert. What do you go by, Mike? Mike. Does the Bill of Rights grant any rights?
Does the Bill of Rights grant any rights?
This is another trick question. Does the Bill of Rights grant any rights? Okay, why do you say yes? What's it called? What's the name of the document?
Bill of Rights.
Does the Bill of Rights grant any rights? Here you go.
Is it reserve rights? Or natural born rights?
Get closer.
Does it affirm rights?
Close. Read the first 4 words of the First Amendment. Right there.
It keeps the government from affecting our rights.
Yes.
It's mostly exclusionary.
What do you mean?
I mean, saying what you can't do instead of what.
What who can't do? Read
Right, Congress.
read the first 4 words of the First Amendment. Please read.
Oh, Congress shall make new.
Stop. Actually, first 5 words. Sorry.
Law.
Sorry, I can't count. There are these T-shirts that say Congress should stop with the first 5 words of the First Amendment. Congress shall make no law. Period. You can Google that online, right? Congress shall make no law. If you look at the entire Bill of Rights, they're all framed of what Congress can't do. Congress can't make a law respecting religion or speech. They can't restrict the right to bear arms. They can't quarter troops. They can't have unreasonable searches and seizures. They can't take your property without due process of law, right? Go up and down. Every single aspect of the Bill of Rights, which is not a good name for it. I don't even like that name. That name didn't actually come to almost 100 years later. It wasn't called that initially. But every single provision, the first 8 amendments of the Constitution, reflect limitations on government. And that's not an accident. It says, Congress shall make no law abridging the freedom of speech. What is this freedom of speech? Where does it come from? Did it magically appear in 1791? Well, the Constitution doesn't say it creates it. Did it exist in 1789, before the Bill of Rights was written? Did it exist in 1689 with the English Bill of Rights? When did this right of free speech exist? Right? Gwen, when did this right of free speech emerge?
I feel like it was always there.
Always? How could? What do you mean it's always there? What are you talking about? The government was only a couple years old. We declared our independence in 1776.
Affirming something that everyone already feels.
What do you mean affirming something everyone already feels? Eddie?
It was Locke's idea that
Locke.
the divine right, or it's not given by the state or given by society, it's given by our creator, I guess.
Like that? Like that? So we go back to Jefferson, right? So I asked you a trick question before, which wasn't fair. Could Congress have passed the laws banning free speech in the year 1789? Not according to the philosophy of those who were in existence then. You didn't need a Bill of Rights to recognize this, because as was written by Jefferson, there are certain rights which you're endowed by your creator with. And we can discuss the basis of these later, which is not the focus of the course, but the laws of nature and of nature's God. In other words, they're pre-existing rights. These are rights which are, in the words of the 9th Amendment, always retained by the people, regardless of what any government does. Now, this is not the prevailing philosophy today, which is fine, but at least in time of Jefferson, they recognized that there were certain rights which could not be restricted. And when the king usurps those rights, that's when you start rebelling. That's when you polish your musket, so to speak. Not in that sense, right? I'm going to get in trouble with this class. Okay. Right? So it's a trick question. The mere fact, and I like someone use the word reaffirm or affirm, I think those are good words, right? The fact that these rights are recognized and there are limitations placed in the government doesn't actually vest you or grant you with any rights. It merely recognizes these rights exist and says, hey, government, get your dirty paws off, right? Get your hands off my rights, or whatever these happen to be. So the Bill of Rights wasn't entirely necessary. I'm very grateful it's there, because subsequent generations were not so open-minded about the nature of rights, which is to be expected. But this proves the point. Having the Bill of Rights by itself is meaningless if you ignore what comes first, which is the Constitution. The structure of the Constitution exists to make sure these rights have teeth. These rights have meaning. Right? Are there any questions so far? Stop. If you have any questions, please stop me and put your hand
Is
up.
that what is intended by it being in the Constitution, being a negative document?
Yes, so explain what you mean by negative. That's the.
I think it just dawned on me that it's just, it says what it cannot do.
Exactly.
It cannot infringe upon these
The
rights.
Constitution is sometimes called a negative charter of liberties, right? It doesn't grant you any freedoms. So for that mentioned the United Nations. Go read the United Nations Declaration of Human Rights. It's this long document that says you have the right to health care and the right to housing and the right to food and the right to education, all these other things, right? Some state constitutions have that as well. Our Constitution is negative. It simply says government can't do this. And by putting the check in the government, the philosophy is things will work out okay. That as a matter of statute, legislatures can give education, they can give health care, they can give food or whatever else, but it's not a constitutional right which the government owes you. It's a very different mentality, and that mentioned the United Nations, right? So even before we get to this Bill of Rights, we start off with our 3 branches, right? So let's focus on Congress first, right? What are the ways that Congress can check itself? How does Congress check itself? Not like it's like a check, self, you check yourself out. Like how does Congress check itself? I'm sorry? I'm talking only Congress. Congress by itself, the 2 houses of Congress. Zach?
The requirement for majority vote.
Ah, what do you mean?
As in, if less than, say, 50% of the Senate or the House approve a bill, or if you don't get at least half approval of a bill in the Senate or the House, then it can't actually pass legislation.
Okay, good. Let's focus, though. How are members apportioned between the 2 houses? Okay. How do you determine the number of members in the House of Representatives? Population. Okay. How do you determine the members of the Senate? It's fixed. Okay. This was the great constitutional compromise, what's called the Connecticut Compromise. If you ever go to Connecticut, they say in their license plate, the Constitution state. I think that's a stretch, but that's what this is what they're claiming credit for. It's like, really, that's it. But anyway, the Connecticut Compromise, this is the greatest accomplishment, I guess. I don't know, but Yale wasn't that important, right? So they have this compromise, right? While the Articles had a fixed number of votes per state, our Constitution bases it on population. So a bigger state like Virginia may have, a bunch of votes, and a small state like, Vermont may have a tiny number of votes. But the fix was you had the Senate, where Wyoming and California have the same number of senators, right? That pisses people off from California a lot. But they have the same number of senators. So here, even before we even get to the other branches, we're only in Congress, we're having a check on itself, where this huge body that represents a lot of different people needs to pass a law the exact same way that a fixed body with longer terms can pass laws. So there's a check there that the interests of the wide will be versus the narrow. But one other way, today Jason?
Originally.
Yeah, you're seeing my sentence. So originally, how were senators appointed?
By the state legislature.
And what's the significance of that?
Because they owe an allegiance that is different than to the masses.
Exactly.
They have a longer term and a different allegiance, and they might come to a different conclusion.
Exactly. So today we have the 17th Amendment, which provides for the direct election of senators, right? You've all voted for Senate. If you haven't voted, you really should. But you can all vote for senators or whatever. In the original Constitution for the first 120 odd years, they didn't have that. It was the state legislature who appointed the senators for these 6-year terms. So there's another important check, that it wasn't the people of the state, but it was the state government sending people to Washington. And they were representing the interests of the states. So even in the House of Representatives, the House of Representatives was appointed by the people through elections. The Senate was fixed at 2, but appointed by the state legislatures, right? There are so many gears interlocking in that function of how to even get the 2 houses of government, that at every step of the way, you have the interests of the people of the states. You balance the interests of the big states versus the small states, right? You balance the interests of the state legislatures. And they all have to agree by majority vote to do anything. Think of how many roadblocks you have to get to pass a law. I'm sure you've all seen the Schoolhouse Rocks, right? How a bill becomes a law. It's hard for a reason. Things aren't supposed to move quickly. If you saw the flyer, which is hanging in every elevator, Justice Scalia has famously said, gridlock is a feature, not a bug or a constitution. I think you see this very clearly. Okay? There are other provisions which you may not have ever thought of. But did you know that one house of Congress can't recess without the other one's permission? This is what happened with the recess appointment case. So if the Democrats want to go into recess to let President Obama make a recess appointment, the House Republicans say, no, you're not going on recess. There are all these little checks to make sure that each house works with the other. Okay?
Spending bills from the House.
Thank you, yeah. All bills raising taxes must originate in the House of Representatives. Why? It's the closest to the people. You can't have the Senate passing revenue bills, right? What about Article 2, the executive? How is the executive checking the power of the legislature? How does the executive check the power of the legislature? That? Exactly. If both houses pass majority vote and the president doesn't like it, he can veto it. But what can the Senate do over that? If a 2/3 vote of the Senate and the House, they can override the veto. This was unprecedented. In England, when the king said no to a law, that was it. But here, the elected branches representing the interests of the people and the states could override the executive's power. This would have been an act of treason in England to actually override the vote of the king. You'd be executed for this. Here, this is part of our constitutional governance, right? How does Congress, though, check the power of the executive, right? What can Congress do to limit the power of the executive? What power do they have? What do you mean power of the purse? Yeah, well, it's supposed to at least, right?
Yeah.
We'll get to that soon, right? The executive can't take money out of the treasury himself. He can only spend what Congress gives him, right? Also, when you give the president money, you put strings on it, say, here, I'll give you this money, but here's how you have to operate it. How else can the Congress check the president? That?
Confirmation
Good. What do you mean by confirmation?
on the appointment of cabinet level.
Exactly. So if the president wants to appoint a Secretary of Defense or a judge to the Supreme Court, they need the Senate to approve. Same for treaties. If the president wants to enter into a treaty with France or whatever, you need 2/3 of the Senate to approve. So there's a check there. How else can the Senate and Congress check the president? Impeachment. What's impeachment?
Well, I can't remember how exactly it works, what votes you need, but you vote to kick that off.
Right. So the way it works is that a majority.
House,
Exactly.
And then the Senate does the trial.
Exactly. This is actually a really impressive theme. You can read about this in the Constitution. But the House votes by majority to bring articles of impeachment, and the Senate tries him. And in fact, the Chief Justice presides at the trial. This happened with President Clinton, with Chief Justice Rehnquist presiding at the trial. It's a really crazy idea. But there's an impeachment, right? How else? What's one other clause that makes sure the president does what he's supposed to do? So no one knows this one. We'll be talking about a lot this semester. Take care. The Constitution requires the president to, quote, take care that the laws be faithfully executed. The president cannot suspend the laws. The president cannot make laws. This was Youngstown Cheat and Tube, right? Everyone remembers Justice Jackson's 3-part whatever Zone of Twilight. But what actually happened was President Truman decided to pass a law himself. He said, I'm going to take these steel mills, even though Congress didn't give me that permission. The president cannot suspend the laws. He has to comply with the laws Congress gave him and can't do anything else. This hasn't always happened. Okay. What about the courts? Right? How did the courts play a role in checking the executive power and the legislative power?
They kind of modify and enforce the legislation, like what the laws that are made when an issue comes up about it, they have to interpret it.
Okay. Maybe someone who didn't like Marbury. That you don't like Marbury?
Yeah, that would be my question too. When I first read before all the judicial review, I don't see the check and balance from judicial at all.
Oh, so what did Hamilton say about the judiciary in Federalist number 78? How did he refer to it?
No influence over either the sword or the purse.
What is a famous phrase? What did he call it? The blank branch. The least dangerous branch.
The least dangerous branch, yes.
So Hamilton in Federalist 78, which was in the reading for today, called the judiciary the least dangerous branch because it didn't have the power of the sword, didn't have the power of the purse. This is a theme which I discussed in ConLaw at length. I won't do too much here. But ask yourself, why does anyone obey the courts? Right? There's a famous story which isn't true. Andrew Jackson apparently told John Marshall, you've made your ruling, now come enforce it. Never happened. It was totally fictional, but let's pretend it happened, right? Why does anyone need to respect the courts? They can't check anything. They can't cut off the funding of the president. They can't tell Congress they can dissolve and they don't have to meet. And it's here that we discuss things like the rule of law and legitimacy and a recognition by the Constitution that the courts play a very important role. Under the Articles of Confederation, were there any courts? None. There were only courts in our United States Constitution system. So there was this recognition that we have to have the courts as a means of ensuring the other branches behave. So even if you don't like a ruling by a court, you should know that in the future, they play an important role to protect other rights you may like. So even though you might not agree with the courts today, it's like, oh, that decision's bad. Having an independent judiciary is essential for this, right? As well, judges can be impeached. This has not been done very often, right? Judges can be removed from office. This has only happened, I think, a dozen times in 200 years. If you ever read some history, so Chief Justice Earl Warren was the Chief Justice during all the desegregation cases. And if you were to drive throughout the South, I'm sure in Texas, in the 1950s, you'd see billboards say, impeach Earl Warren. And there were actually calls to impeach the Chief Justice for a decision in Brown versus Board of Education. So chew on that for a bit. So the Constitution has, at a very high level, all these gears, if you will, interacting and grinding and placing a check at every step along the way. The process of passing a law, having it being executed, and having a court review it is a lot of stuff that has to happen. It's not quick, not efficient by design. Now, if you go down to Article 5 of your Constitution, we talk about the amendment process, right? Can the Constitution be amended? Yes, but it ain't easy, right? The Articles of Confederation required unanimous consent of all the states to amend. How many states do you need to ratify an amendment to the Constitution? 3/4. So the process works like this, right? If 2/3 of each house agree, or if 2/3 of the legislatures agree, you hold a constitutional convention. And there's not a convention of the government. This is a convention of the people. The state appoints ratifying conventions. And if 3/4 of the states, not Congress, if 3/4 of the states agree, you change the Constitution, you amend it. This has only happened in 200 years, 27 times. We have the longest serving government in the entire world by a lot. No other government's lived under a single document. Now, you might say, oh, at Magna Carta. So we all know Magna Carta was written in 1215. It's its 800th anniversary in England. But England's gone through a number of constitutions, but they don't even have a written constitution. They pretend to. They don't really have one. They're fakers, right? They'll say, oh, we have Magna Carta. Well, whatever. It's under glass. So this government has sustained itself through 200 years. And I think what you'll find in this class is virtually every single step along the way has been guided by the Constitution. Following it or not following it has created very good and very bad aspects of American history. Okay? So any questions in the Constitution? All right, let's shift gear a bit and talk about the paper. I always want to reserve at least 15 minutes or so at the end to talk about the writing process, because this is a skill that will serve you very well. You may not remember a thing I say about the Constitution, but the thought process you get from this will actually stick with you, I hope at least. So the first step in your process of writing this paper should be coming up with a topic. And it's very important to come up with a topic to consider a few things. And this book by Eugene Volokh is so good, and it's a very easy read. It's not dense, and it makes things very clear. He numbers a few even. So a couple of things you think about, right? You first need to have a claim. Okay, what do we mean by a claim? This is on page 1 of the introduction. This is chapter 1, page 1. You You need to have a claim. You need to have some sort of thesis, some sort of statement about the law. And these statements about the law take one of two forms. It can be either describing something, one, or saying why something should change, two. So you can say, here's this case, and I'm going to describe why it does this. Okay, that's a good paper. Or, this law is really unfair. It should be changed to something else. Okay? But the best papers combine the two. Here's what the Supreme Court said in this case. Here's why they messed something up. And here's what the court should do instead. Or, here's what the Texas Supreme Court did. They forgot about this other issue. This issue is unresolved and should be resolved by some other court. Okay? What makes the best papers are papers that combine describing it versus giving a suggestion of what should happen. Okay? Now, if you just want to get by in this class and, you know, do okay, you're okay with a descriptive paper, right? That'll get you a B, right? That'll get you a B, right? But if you really want to excel, and which I encourage you all, try to think of some sort of issue in the law that maybe is ambiguous or vague or wrong. And what's a better way of doing it? That is the legal argument, right? When you make an argument to any court, you're saying, Your Honor, the judgment should be reversed. Why? The why is the hard part. It's really easy to say that decision was wrong, but the judge will say, okay, what should I do instead? Right? How should we rule this case? What should the precedent be? This is where you make very strong legal arguments. It's very easy to be mechanical and simply just do the same thing over and over again. This will, I think, train you. So, right. So, how do you find this problem? So, you have about a month, so you have some time to think about it. But think about all the cases you studied in ConLaw last year. Go back and maybe review your outline, and maybe there was some case that drove you crazy, right? It's like, oh man, that opinion made no sense. Don't do Marbury. Marbury's settled. Marbury's done. But some other case, right? That case was not persuasive. It didn't make sense. There was some sort of contradiction. The reasoning wasn't supported, right? Try to think of these decisions. And you don't have to be the entire case. You don't have to say that Roe v. Wade was wrong, right? Or actually, it's not a federalism case. Let's say the Obamacare Medicare expansion case was wrong. But if you focus on one aspect of it, stay narrow. Law students have this terrible tendency to take on much more than they can chew. It's a very bad tendency. So the reason why I want you to come talk to me now is I can focus you like a laser and get you on target, so you don't spend all this time flying around and flailing. It takes discipline, which will be very useful for you later in your legal careers. Okay, so it's not enough to find a problem and identify an ambiguity, but maybe propose a solution. And it's not as simple as saying the court should do this because I think this is a better answer. Why? Is there precedent on your side? Is there policy arguments on your side? Are there moral reasons on your side? There has to be some rationale of why a court should listen to you. Because the goal of these kinds of papers isn't just to impress academics. Trust me, you don't need to do this, right? Ultimately, the goal is to seed an article that might change the law. And I'll give you a perfect example. Now, you all studied, or at least I think you did, the Obamacare case. And in that case, the main question was, can Congress regulate a class of inactivity, right? Do you know where that idea came from? I was there. I'll tell you the story in a minute. So it was November 2009. I graduated law school not too long before. I was clerking. And I was at the Federal Society convention in Washington, D.C. Okay? This is a huge gathering of lawyers, mostly conservative libertarian lawyers. And they have this huge hallway at the Mayflower Hotel. This is like where they hold, inaugural balls, this beautiful hallway. And I'm walking around. And at that point, Congress was still debating this Affordable Care Act law. And then we weren't really thinking about it. And then so some guy says to me, he's a lawyer, he says, oh, Josh, what do you think about this health care law? I'm like, I don't know, what's the big deal? He's like, well, it's making people buy health insurance. So I said, yeah, but it's commerce, right? Why couldn't Congress regulate interstate commerce? This is such an easy case. So he said, yeah, but they're making you buy a product. I'm like, well, so what? You have to buy car insurance, other things. He's like, yeah, but this is different. It's the federal government, not the state, making you buy it. I was like, so, but even under Gonzales v. Raich, there's some sort of impact in interstate commerce. If you don't have health insurance, it'll affect others. So he goes, Josh, you're a young lawyer. How about you write something for me on this? I said, I couldn't. I was clerking. I was like, I can't do it. So then in walks another guy named Randy Barnett, who's this huge ConLaw professor. And they asked Randy, what do you think? And Randy says, I haven't given it much thought. So Randy Barnett, who was the architect of the Obamacare case, front page of the New York Times, hadn't given it much thought. Okay? Mind you, we're in November 2009, 1 month away from this bill passing the Senate. What happens next? One of the guys at the convention knew a law student. His name was Robert Alt. He had written a case note for the Law Review, the Case Western Law Review. It's in Cleveland, Ohio. And his entire Law Review article was about Gonzales v. Raich, but one specific part. He noticed that in Justice Scalia's concurring opinion, he used the word activity over and over again. He said that Congress can regulate activity that has an effect on interstate commerce. Congress can regulate this activity and that activity. So he had this bizarre article that really had no purpose, which said, what if Congress was regulating inactivity, right? What if Congress wasn't regulating a class of activity, but they were basically making someone do something for not having insurance? And he wrote this article like 4 years ago, or 4 years before that, at that point, it was 2006 or so. And this article was taken up, and the people with Randy Barnett said, this is a good idea. Let's run with this article. That was November of 2009, right? Less than 3 years later, that article was accepted by 5 justices of the US Supreme Court. A random article that seemed to have absolutely no purpose that a student wrote at the Case Western Law Review almost stopped Obamacare. I tell this story whenever I speak on the circuit to explain to people that your ideas do matter. Odds are they may not ever wind up in the Supreme Court brief, and we should be frank about that. But the approach of thinking about constitutional issues can have such an important impact in so many different contexts. So take this class seriously. If you write a good paper in this class, it could be something you can turn into a published article later. And that's a nice feather to put in your hat on your resume when you apply for jobs. If you're on Law Review, you can't use this for your Law Review note. So don't even ask me about that. That's cheating. But you might be able to publish it in another journal. Okay? All right, so I talked about the claim. I talked about it has to be a novel, right? So this one, in this class, I'm not going to be too strict on novelty. The reason why is because I know you have a short period of time. So generally speaking, you should write something that has been really written before. I'm going to relax after this class. You don't have to be totally novel. If you want to, go for it. But it's very hard to find something new to say. The problem is, as more articles are written, there's less stuff to write about. Although I don't ever agree with that. But it's there. Another factor they discuss is non-obviousness. And what does that mean, right? It can't be something that's already been done. It has to be something that has a twist on what's been done before, right? It can't be something that, Congress wants to pass a law banning libel. That's unconstitutional, right? You have to do something new. It discusses utility, and this speaks to the point I made. You have to discuss, why is this useful? And it's perfectly fine to say that this is an interesting topic that legal scholars should think about. That's okay. But what's this going to have? Is it going to change the way we think about certain topics? Will it impact the way courts look at something, right? And finally, your argument has to be sound. You have to have legal arguments. In terms of Iraq, this is the A. The A is always the hardest part, right? Everyone hates the A. That's why if you ever take an exam with me, I tell you, I don't want the I, the R, or the C. Just give me the A, because that's the only part that matters. This paper's A, a lot of A. So you need to have sound arguments, and these are skills that will last you far longer than remembering various nuances of constitutional law. This is what actually trains you to make compelling arguments, if that's what you're so inclined to do. All right, questions? Oh, come on, I just threw a lot of stuff at you. What questions do you have? Nada? Yes, Beck?
I guess this is obvious, but our papers don't have to be complete by the time we're doing the presentation.
No, and that's exactly right. If you look at the calendar, of the course, your papers are due either May 14th or May 3rd, depending on your.
You're just kind of going over.
But your presentation has to be substantive. Don't phone it in, because I'll know. And that will contribute to your grade. Because at that point, I've already seen your outline. I've already seen your research topic. And depending how you have done it, I've already seen your 500-word introduction. So if you've done what you're supposed to, I've already seen enough to know that you're in business. If you come in and you fake it, you're not going to be in good shape. Yes, you go. I'm going to really say no PowerPoint. It's a terrible crutch people use. They read from it, and it's bad. If you notice, I don't use PowerPoint. I'm probably one of the few professors who use computers that doesn't use PowerPoint. It's a really bad crutch. Try to learn to speak extemporaneously. You actually read about lawyers using PowerPoint in courts, terrible effects. I actually read once there was a prosecutor that actually had to declare a mistrial because she had these stupid animations saying guilty, guilty, guilty. And the judge actually declared a mistrial. I mean, this is so stupid, I can't even fathom it, right? Can you imagine you're a prosecutor? What are the criminal kids with? It's like, you know, the transcript, guilty, guilty. Use your words. That's what you'll have in any court. You'll submit a brief. You'll make your argument. I don't need flying animated GIFs of James Madison. I know, you know, I don't need that stuff. So yeah, I'm going to say no PowerPoints. I actually was anticipating this question. And I'm going to say no.
If anyone has a flying animated GIF of James Madison, I'll just email it to me.
Yeah, put in your email signature, right, with a little LOL cats. All right, what else? Dad, I think your hand was up. All right, anything else? All right, everyone have a wonderful week. I'll see you on Thursday.